Good afternoon, everyone. Welcome to the Appellate Division. Hope you can hear me. Welcome to the Appellate Division, better. First Department. We have some 4.5 hours of argument this afternoon, so please keep that in mind as I call the calendar. Remember that we have your briefs, we have the record, we're fully familiar with the facts of your cases, so please, when I ask for time, please ask only for the time that you'll absolutely need to make your arguments, okay? All right. People versus Tremaine Manuel is submitted. Natira versus Velos Livery Rentals, submitted. Albertina C, submitted. Zong versus Matrunga. Someone there? And is, oh, I see, okay. And your time, please? 6, 2, and 6, thank you. Berker versus Green Tech Capital Advisors and Molnar versus Green Tech Capital. Those cases are together.
Good afternoon, Your Honor. Patrick Shea for Paul Hastings for the appellate, Green Tech Capital Advisors. Both the Molnar case and the Baker case involve the same legal issues. Unopposed argument both. At the same time, we request 15 minutes, 2 minutes reserved for the law.
Good morning, Your Honor. This is all right for respondents. I need 5 minutes for response.
Okay, thank you. I'll do 6, 2, and 5. People versus Arcadio Cortorial and People versus Juan Ramon Cortorial.
For Arcadio Cortorial, I'll request 6 minutes and 1 rebuttal.
And for Juan Ramon Cortorial, 6 minutes and 1, please.
And you're going to do 7 on both. Is that right or not?
Yes, I didn't know how the court wanted to do it.
What I'd like is for you, for both to argue first and then for you to respond. And I'm going to give you each, and you're going to do 7 on for total? Yes. And I'll give you both 5, there are many similar issues in there. I'll do 5 and 1. 5 and 1 and 7 for you, okay? Rutgers Casualty versus Smith.
For appellate, 6 and 1 for rebuttal. For respondent, USA Veterans Construction, 3 minutes.
Okay, 5 and 1 and 3. Schukenhaus versus Frolova. Three minutes. 4 and 1 and 3. Thank you. Hall versus Banks. Hall is submitted. JRD Unico versus Star Indemnity. Good afternoon. You've been alerted that the appellant won't be here, correct? You don't want to submit? Well, that's not a submission. Okay, I'll do a submission. Excuse me?
If there are any questions that Your Honors may have, that's what I would use my 3 minutes for.
We don't, is there any Aren't any questions now? Would you like to submit, or you want to argue against yourself? It's okay. Okay, submission. People versus Carlton Solano? Submission. And Board of Managers versus Delsha is a submission. First case for argument is Zong versus Matranga.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court, my name is Arlene E. Lewis. I represent Appellant Peter J. Matranga in the appeal before you today.
So we've seen the video, we've watched it several times, and your client has the light in his favor, correct?
Yes, that is correct.
Okay. He seems to be going fast as you watch him proceed across the intersection, but both experts put him about the same speed, which is 14.1 miles per hour, 14.3 miles per hour. That's about the same. But he doesn't seem to slow down at all in his speed. Is he using all of the care that he should in the way he proceeds here?
Your Honor, it's my position, my client's position, that yes, he was indeed using all of the care, reasonable care, under the circumstances. He was proceeding at 14.1 miles per hour approximately, as Your Honor just indicated.
Is there a speed limit here for bikers different than the traffic?
It is not different.
What's the speed limit?
Applicable speed limit is 25 miles per hour.
So he's well under the speed limit.
Yes, ma'am.
But counsel, it's also true that defendant's speed must be judged as to whether it's safe under the circumstances, correct?
Correct.
And does the film shows a relatively narrow slice of what could be seen that day. Is that right?
Yes, it is, Your Honor.
So do we know even how many pedestrians were on the other corner, the opposite corner that he crossed to get to the corner where he ultimately hit the plaintiff? Do we know how many pedestrians were on that other corner?
We do not know, Your Honor. We're limited to what is shown on that video.
And I think, I think also that your expert was saying that it was theoretically impossible. There was a theoretically possible, or there was a possibility of an evasive maneuver. But he's saying that he could not have made an evasive maneuver without putting himself and other pedestrians at risk. But he never says that there was no way that an invasive maneuver could be made. He says there was a theoretical possibility.
Yes, the expert, the defendant's expert, explained that there were a number of circumstances at play, Your Honor.
Right.
There was the curb, the median to the right. There was the curb behind her, and she was walking with her left arm extended with a bag on wheels behind her. So he would have to make an estimation as to how could he protect himself proceeding on a bicycle.
But he testified at his deposition that he realizes all that because he's bicycling in the city of New York, and he did testify that he's aware that he has to be, as a bicyclist, conscious of the traffic patterns, cars, pedestrians. So he knows all that, and that goes to Justice Moulton's point about the block before, or the even further down. What was the pedestrian traffic that was he aware of and cognizant of? Because in his EBT testimony, that wasn't fleshed out. It was all concentrated at the moment that the accident happened.
Yes, so he expressed surprise at the plaintiff having walked out into his path.
No question, but in terms of what his expectations are, because his expert's saying it was a theoretical possibility that he could perform an invasive maneuver, and that just goes to Justice Moulton's point, is what were the pedestrian traffic situations or presence as he was coming up First Avenue? Because it was this around 6 o'clock in the evening now, right? It's still daylight, it's before Memorial Day weekend. There's a lot of foot traffic out there, at least from the video I saw. So it would have been interesting to see what he was in his mind at that point.
Does it matter, can I ask you, does it matter what foot traffic there was on a preceding corner where other cyclists and this cyclist passed already and didn't hit anyone, regardless of whether there were tons of people or not? There were cyclists at different speeds, and this cyclist passed through that area at the speed he was going without incident. What difference does it make with regard to what people, or how many people there might have been on another corner? Obviously, then, I guess that would work in his favor, since he negotiated those corners fine under similar circumstances.
Yes, Your Honor. He's limited, of course, to the questions that were posed to him by opposing counsel. There was no indication, however, in his discussion as to the events of that day that he had encountered any other pedestrians stepping out into his path.
Will you move for summary judgment here,
Yes.
right? So you have to exclude any questions of fact. So the question is, were there questions of fact here that you did not exclude?
I do not believe that there were any, Your Honor.
So,
Counsel? Go ahead, Justice Romer.
no, go ahead.
Counsel, but how do you address the fact that you have conflicting opinions from both experts regarding the defendant's speed and what truly caused the accident? Because it's clearly a question of credibility. There are two conflicting opinions here.
Well, there's no question that the plaintiff stepped out into the roadway, the marked bicycle lane, against a red light for pedestrians. He was proceeding with the green light. He was in the bicycle lane. He was operating his bicycle below the posted speed limit. And
Is there really any conflict here between the two experts where they're just 0.2, I mean, they're not exact, one's 14.1, one's 14.33, but is that really any difference that would raise a question of fact when both are over 10 miles below any posted speed limit?
And that is our position, Your Honor.
Is it, I'm
It's of
asking,
no
so
moment.
you don't think it is?
I'm sorry?
Yes, no, I think you answered the question.
Okay. Yeah, so there's no, they're both speeds, they're slightly different, but they're both well below the posted speed limit.
So does that difference, 0.2 difference, indicate a question of fact?
It does not. It
So-
does not.
So the question of fact would be with regard to whether or not he took all care?
So based on the trial court's decision, the question of fact seems to be, according to the judge, whether or not he did all he could to avoid colliding with the plaintiff.
And so
Mr. Matranga testified that he applied his brakes, he observed the plaintiff when he was more than halfway through the intersection. The expert's affidavit explained that there's a difference between perceiving a person stepping out than recognizing them to be a threat because it's an unexpected action.
You mean he
not-
didn't expect the person to walk into the roadway? He saw them where they were stepping off the curb, but didn't expect a continuous walk into the roadway? Is that what you're saying? I'm not-
Yes, Your Honor.
Okay, you have some rebuttal time. Your red light is on.
All right, thank you, Your Honor.
Okay.
Good afternoon, Your Honors. Joshua Block on behalf of the plaintiff respondent. This case really comes down to proximate cause and comparative negligence. As this
Well,
court is
what
aware-
negligence is there on the part of this bicyclist who had the right of way? He had the green light, and he was going more than 10 miles below the speed limit.
He was going below the speed limit.
I beg your pardon?
I said I was agreeing with Your Honor that he was going below the speed limit.
Yeah.
But that's not the end of it, because under the VTL, he has to be acting reasonably under the circumstances, under VTL 1180, as well as 1146. And in this case, 14 miles an hour approximately was not reasonable. As Your Honor,
Why wasn't it reasonable? He had already come up the street. He had already crossed one corner, presumably with people. There are several bicycles that go by. He's not the only one. He made it through. Presumably, the traffic is about the same on both corners. No incident. Why is this different? Does it have anything to do with the fact that the plaintiff ignored the light, walked against the light, and never stopped and never looked and walked right into the bicycle path?
well, there's a few factors, Your Honor. Firstly, this is Friday, about 6:30 before Memorial Day weekend. You know, it's bright, it's sunny, the video shows there's a lot of people. There's cars, there's the bus, there's other bicyclists, there's
Of course, but they all make it through, and it's only the person who crosses against the light and walks right into the roadway. Is that not the sole proximate?
She's the only one who's hit.
I just have one question. Is that not the sole proximate cause? Is she not the sole, her actions, not the sole proximate cause of this accident?
No, and I believe that the video shows other jaywalkers, but more importantly, the defense expert testified that it would take 1.8 to 2 seconds for him to safely come to a stop, including the perception reaction time. He also said that the plaintiff was within the crosswalk for 1.9 seconds.
And I have a question for you, sorry. You said perception of the accident time. Perception, exactly does that mean?
No, perception reaction time, Your Honor.
I'm sorry, perception of the action time. What exactly does that mean? The point at which he sees the person...
The difference between when you...
Let me just ask the question. The point at which he sees the person on the curb, the point at which he sees the person step off the curb, or the point at which he sees the person and realizes that the person is now crossing into the crosswalk? Because there are many people, this is New York after all, who stand at the edge of the curb. They'll walk right up and stand at the edge of the curb. You figure they're going to stop. There are those people who walk right up, step off the curb, but you figure they're going to stop. This is a person who walks right up to the curb, steps off the curb, doesn't stop, doesn't hesitate, keeps walking into the crosswalk. So which action did he perceive there? Which of those three?
I don't know, Your Honor, but this is also not my motion for summary judgment. I would say he recognized the plaintiff.
But I believe it's your expert who said he didn't perceive the action. So I'm trying to figure out what, didn't you say that?
No, I'm talking about the defendant's expert.
Oh, I'm sorry. I thought you said that he didn't, there was, from the time he perceived the action.
No, but to finish answering your question, the defendant testified that he saw the plaintiff step off the curb. And the expert said 1.9 seconds. So presumably that means 1.9 seconds to stop the bike, which is what the amount of time that he could have done so safely. In addition,
How far away from the cyclist was the plaintiff when she stepped off the curb? When he first saw her, he testified that she was approximately 6 feet to 10 feet away from him. So at that distance and at the speed that he was traveling, could he have been able to stop his bicycle?
I believe so, according to their expert. And also, I would also add, the corral is what I'm going to call the bike lane, given the curbs on either side. He could have swerved before he reached that. The defense has concentrated on the fact that the plaintiff was taking...
I'm just not clear on what evidence there is that he could have done this or he could have done that. What is there?
Because according to their expert, he should have seen the plaintiff 1.9 seconds before the collision.
Counsel, in fact, the other bicycles that are depicted in the video, they're all going slower than the defendant, correct?
Yes, Your Honor.
But those
Might that be
bicycles,
some, I'm sorry, go ahead, Judge Mendez. Or might that be some evidence of what what the safe speed was under the circumstances, which is the standard we're dealing with here?
Absolutely, Your Honor. And that's additional.
But do you answer that question, but do you have some evidence that if those bicyclists were faced with a person walking right into the roadway without hesitation or warning, that they would have been able to stop the bicycles? They weren't going 14 miles per hour, but certainly they were going about 10, 7, 8, half of the speed he was going. How would they have been able to stop for, I'm sorry, not how, but what evidence do you have that they would have been able to stop their bicycles for someone who avoids every indication, breaks every kind of rule there is, doesn't stop at the stop walk, doesn't, and without warning, just walks right in front of them? How are they supposed to anticipate that she is not one of those people who is going to stop at the corner or stop at the curb, but is just one of those people who's just going to walk right in front of oncoming cyclists?
Because this is a pedestrian in New York City, the corner of 91st and First Avenue, Memorial Day weekend. Jaywalkers were not unexpected.
Jaywalkers are not unexpected, you're right, but they're not expected to just walk right into the street on oncoming traffic.
Other jaywalkers are observed. It's not unexpected that she would continue.
She never looked to the right or the left.
I'm sorry, what's that?
The video shows that she does not look left or right. She doesn't look.
I don't think that's clear enough, and I think the video itself, and I do believe that she testified that she looked both ways.
Oh.
But the issue here is comparative negligence on behalf of the defendant,
Well,
whether or not they've met their
The bottom line is that you're not moving for summary judgment. It's the defendant's moving for summary judgment, correct? So
Absolutely.
you just have to raise a factual issue. And the other question I have, well, not a question, but their expert never says that there was no way for the defendant bicyclist to avoid the accident. He says it's theoretical possibility that there could have been an evasive maneuver made by the bicyclist. He says that.
Yes, Your Honor.
So that's a factual issue right there, whether or not could he or he couldn't, right?
Absolutely, Your Honor. I 100% agree.
but any maneuver that he makes, he's got to make sure that it's not going to be a maneuver that's also going to result in serious injury to himself, correct?
Yes, Your Honor.
Okay.
Unless Your Honors have any more questions, we respectfully request that this court affirm the trial court's order.
Thank you.
Your Honors, I believe that it is important to think about what the burden here is. It's to show that his actions were reasonable under the circumstances.
But how do we show, if you're saying that, reasonable under the circumstances, isn't that usually something that requires a question, raises questions of fact as to what's reasonable? Isn't that usually within the jury's purview?
Well, that's the basis of their opposition to the motion.
But
and I
I'm
don't-
asking what your basis is for asking for summary judgment, for seeking summary judgment and saying that there are no issues of fact. It's your expert who's saying that he had 1.9 seconds from some point, I'm not sure what point, to anticipate an action. So is your expert not raising questions of fact as opposed to eliminating them?
I do not believe so, Your Honor. I believe that the expert has pointed out the time at which the defendant first observed the plaintiff, and then he talked about there having to be a reaction once you perceive someone stepping out, and there's a point at which that person becomes a threat. You don't expect, as you indicated earlier, that someone will step beyond the curb itself. In New York City, you see people walk to the edge of the curb and they stop abruptly. He didn't recognize her as a threat until it was too late for him to stop. He was less than 10 feet away from her. He decelerated. He had to think about his own safety.
That
He
goes
was, in
to
fact,
me,
thrown from the
But what
bike.
you're saying here goes to what I'm thinking as I'm listening to what you're saying. That's for a trier of fact to really either accept his argument or accept that his belief that I didn't have time to stop. You know, I mean, that's what I'm hearing. It's not a matter of law that I can't do anything. I mean, it would have been easier if his experts had said there was no possibility at all for this accident to be avoided. But your expert didn't say that. Your expert said that 1.9 or however many seconds she saw it, and then he says it's theoretically possible that it could have been avoided. There could have been an evasive move. That's problematic for me. Okay.
Do you have anything else?
No, Your Honor.
Okay, thank you. Thank you both.
Thank you.
Baker versus Green Tech, Molnar versus Green Tech, Capital Advisors.
Good afternoon, Your Honors. My name is Patrick Shea, from the law firm of Paul Hastings, and I represent the appellant Green Tech Capital Advisors, LP. This is a breach of contract action.
Counsel, so there's a choice of law claims here, and under our case law, we look to the choice of law and see what it says. This one has Delaware law, and it says that we are to construe it according to Delaware law, which says that substantive issues are controlled by Delaware law, and procedural issues are controlled by the forum state, which would be New York. You pose an argument that talks about the scope, but isn't the scope of this choice of law clause clear in that it applies to the entire contract? I mean, why do we need to go to the scope here?
Your Honor, I think the scope, the meaning, the validity of a choice of law provision are all items that New York courts have said are a threshold issue that must initially be decided under New York law. So, for example, in the portfolio recovery case, where the court had to construe a choice of law provision that also had Delaware in it, the court said, this is a choice of law provision that says governed and construed, but not enforced, not like the choice of law provision here, and therefore it held that Delaware choice of law would apply. But in deciding what that choice of law provision meant, the court relied on New York precedent, because there are multiple cases, I think approximately 10 in New York, and 16 altogether as acknowledged by the respondent in their brief, that say that threshold questions of what a choice of law provision means must be decided by the law of the forum.
Counsel, do you dispute that the choice of law provision means that the breach of contract claims must be determined by Delaware law? Do you dispute that?
Whether a breach occurred in terms of the substantive provisions would be decided under Delaware law.
Okay.
That's a substantive provision.
So isn't it fatal to your argument then that the choice of law provision didn't say and Delaware law concerning procedure, or at least Delaware law concerning the statute of limitations applies here?
It is not, Your Honor, because as this court held in the Ontario v. Samsung case, where a party adds and says it's not just a question of the contract being governed and construed under Delaware law, but also adds the key word enforced, that incorporates the statute of limitations and the borrowing statutes, if applicable, of the chosen jurisdiction.
No, go ahead.
I'm sorry.
I was just going to say, but enforce is not explicit. I mean, the Deutsche Bank case and other cases talks about the explicit statement. If you want it, the particular, if you want it to be Delaware, you have to explicitly state that Delaware is to control the procedural aspect of it. That doesn't say that here, and neither does enforce, the use of the word enforce.
Your Honor, I think if you look at this court's decision in Ontario, it said enforced incorporates the procedural law of the chosen jurisdiction, and in that case, the statute of limitations. That was also Justice Friedman's decision.
But that, in Ontario, that case involved the contract interpreted under New York law, correct?
The choice of law provision and the forum provision were identical there, correct. But I would also say that
So
that is,
it also addressed how to apply New York's borrowing statute in Ontario, correct?
that is also correct, Your Honor. But nevertheless, the basic holding of Ontario is when you use enforced, you incorporate the procedural law of the chosen jurisdiction, in this case Delaware, and its statute of limitations. Because, as courts have said, you have to give some meaning to the word enforced. Because if you just say govern and construe, that means you're going to interpret the contract under that provision. Enforced has to mean something else, or it's mere surplusage. And we always interpret a contract to give meaning to every word. In this case, enforced means you incorporate the procedural law, including the statute of limitations of the chosen jurisdiction. And when you do that, that's Delaware's 3-year statute, and these claims are time barred. Now, in opposition to that, the plaintiffs offer 2 arguments. First, they claim that it's contrary to the New York Court of Appeals decision in Deutsche Bank. That's plainly wrong. The court there was not interpreting what a choice of law provision meant. It was interpreting other substantive provisions, and certainly wasn't deciding whether you would apply the forum law in New York or the chosen law to decide what a choice of law provision means, because there they were one and the same. The forum was New York, the chosen law was New York. So Deutsche Bank is completely off point. It's simply interpreting substantive provisions of a contract. Plaintiffs also have this argument that you should come up with a bifurcated rule and say the exact same choice of law provision should be interpreted under New York law if it involves substantive issues of scope, but under Delaware law if it involves the statute of limitations. That bifurcation makes the law very unclear. There's no policy reason for it. There's not a single court that has come up with such a bifurcated rule. And I would submit to you is suggested here only because they can't overcome the overwhelming weight of authority that says this is a threshold issue, and New York courts interpret threshold issues under New York law. And when you do that, enforced incorporates the statute of limitations of the chosen jurisdiction. There's a separate, oh, I see my time is up.
I'll give you 30 seconds to finish whatever else.
I just wanted to say, turning quickly to the tolling issue, raise an alternative basis for affirmance. Delaware is clear. You don't get tolling if you're aware of the injury. Undisputed facts. Molnar says it in the complaint. Baker says it in her deposition. They were both aware of the injury at the time. They both considered consulting counsel at the time. Under those circumstances, tolling is not available.
Thank you.
Good afternoon, Your Honors. Lisa Solbakken for Respondents Baker and Molnar. The motion court properly concluded that the Court of Appeals has spoken to this very issue.
Would you address counsel's argument with regard to choice of law clause that includes both construes and enforced, as this one does?
Sure, Your Honor. Counsel is speaking in all of the cases to which they refer this court to cases that are interpreting choice of law provisions, which are themselves substantive, under New York law. So we would agree that under New York law, the word enforced has been interpreted to encapture a statute of limitations. Delaware courts, however, have taken a contrary position and have found that that word, that with respect to a statute of limitations, the inclusion of that must be express. So interpreting the word enforced pursuant to New York law is contrary to the mandate of the choice of law provision itself. And we think that's quite clear in Deutsche Bank and as well as portfolio recovery.
Yeah, because, so Delaware doesn't, they're not looking at the word enforced. They're saying if you want to have a statute of limitation on the Delaware law, you better put it in your contract.
100%, Your Honor.
That's the end of it.
That's exactly right. That it's that straightforward. And I would add that there's no word of threshold or not. What Green Tech is essentially arguing here is in a contract that it drafted seeking the application of Delaware law, that New York law be interposed in connection with the definition of the word enforced. And there's no precedent for that. And just to further emphasize the point that was made by the Court of Appeals and Deutsche Bank, the party's intent that Delaware law apply is set forth by the COL provision, but it also provides uniformity with respect to the definition of terms throughout that agreement. So the choice of law provision doesn't have a different state's law interpreting what it means than all of the other provisions in the contract that, without question, are governed by Delaware law. Green Tech provides no real basis to distinguish Deutsche Bank. It does rely on one case, capital Z, that was issued by Justice Friedman, which precedes Deutsche Bank by well over a decade. And then the other cases to which it refers, this court, deals primarily with the issue of whether or not tort claims should be pulled into the purview of a choice of law provision. So, for example, where there's no question that New York law applies pursuant to a choice of law provision, does that New York law likewise apply to a fraud claim? That's not an issue before this court. This is a purely contractual claim. And then in respect, I would just add that in respect to even assuming that Delaware law could possibly apply here, and we do not think it does, there are issues of fact as to whether or not tolling would be triggered under Delaware law. So even in that event, we would ask that this court affirm the motion court's ruling. Thank you.
Thank you.
Just briefly, the plaintiff concedes that if you read the choice of law provision under New York law, enforce means the statute of limitations, and we win. We think that the overwhelming weight of authority requires you to treat a choice of law provision as a threshold inquiry that is decided under the law of the forum. If you don't do that, you walk yourself into a chicken and the egg problem. Do I assume the validity and assume the scope and assume the meaning?
To accept your argument, then we'd have to ignore Delaware law.
Correct. At the threshold area, you have to apply the law of the forum. That's what the cases say. I would tell you, Your Honor, Delaware does the same thing. You can read the 7 cases or 6 cases they cite from Delaware. When they're interpreting in their courts what a choice of law provision means, they don't apply the law of the chosen jurisdiction. They apply Delaware law, because that is by far and away the majority rule in every jurisdiction. You treat choice of law as a threshold issue, you examine it under the law of the forum, in this case, New York, and in that case, we win. Deutsche Bank is not to the contrary. Deutsche Bank did not concern an interpretation of a choice of law provision. Deutsche Bank did not concern whether you look at that under the chosen law or the forum law. It couldn't, because in both cases, it was New York law. So it urged this court to follow the overwhelming majority of weight of authority, decide what this choice of law provision means as a threshold issue under New York law, as the law of the forum. And if you do that, consistent with what the plaintiff's counsel has just said, you should direct the grant of summary judgment in favor of Green Tech.
Thank you. Thank you both. People versus Arcadio Correal and People versus Juan Ramon Correal.
May it please the court. Excuse me.
Oh, I'm sorry. Don't.
Okay.
Thanks.
May it please the court, Joseph Nursey representing Arcadio Cortarial. Prior to trial, the court made clear 3 areas that the prosecution was not allowed to go into. One was that Investigator Malone knew Juan Ramon Cortarial from a prior investigation. The second was the Latin American or Mexican origin of the drugs. The third was the mention of the word fentanyl.
The prosecution violated all three of these areas of law, the areas of fact that the court told them they could not go into. And on two of them, the prior investigations and the Latin American and Mexican origin of the drugs, they violated it multiple times.
So once the court made these clear directives, did the defense have to object when there was a violation of that
Okay,
directive?
the defense did not object to every single violation. I recognize that. But they did object. And what's important is when the prosecution brought out from the witness Malone for the sixth time that, that he knew Juan Ramon from prior investigations, and counsel for Accardio Cortorial brought out that this was the sixth violation of the rule. The court said, these are exact words, quote, to the prosecutor, make it stop. And the prosecutor did not make it stop.
In fact, Mr. Nursey, the prosecutor, in her summation, used the word again, investigation, correct?
You not only used it investigation, but pluralized it, said investigations. She said it hit Malone like a ton of bricks. This is Chichi Rivera. This is the person that he recognized from prior investigations, plural.
And the objection was sustained at that point.
The objection was sustained, and then all three counsel moved for a mistrial, and the court denied the motion for a mistrial. I think beyond just the prejudice caused to the parties by this continual misconduct, I think beyond that, when this court looks at it in the interest of justice, in addition to looking at the issue of law, there has to be a consequence. When you bring it out of the witness 6 separate times.
Well, 6 separate times, but if you had objected the first time,
excuse me, Your Honor?
if you objected the first time instead of the 6th time, maybe it wouldn't have gone so far, right?
Okay,
I mean,
there
that's the
were
problem.
multiple objections. You're correct that Arcadio Cortorial's counsel did not object to the 6th time, but there were multiple objections, I believe, starting at like the 3rd time they did it.
The 3rd time, counsel, I mean, the first time, yeah, to me, once you make your first objection, and then the second, I mean, then it becomes very clear that the prosecutors are disregarding the court's directive. After 3 times, prosecutors say, okay, not objecting, I'm going to keep going.
Okay, one thing, it was a pretrial order of the judge that they couldn't do it. They knew from the start that they couldn't do it.
I got it. Then they took liberties with that order, what they should not have done. I'm not disagreeing with you.
Okay, but even if we say it doesn't start till the 3rd time, 3rd time objection sustained, 4th time objection sustained, 5th time objection sustained, 6th time objection sustained, and the court says, make it stop. And then the prosecutor herself gets up in front of the jury and does it again. And this time pluralizes it, makes it investigations plural.
There were no.
So there was no, sorry, go ahead.
I think you were going to say what I was going to say.
No, I don't know, but,
I think curative. Go ahead.
no, that's not what I was going to say.
Oh, and there was no curative instructions or no curative comments made by the trial court?
The trial court gave the general instructions about argument not being evidence.
Yeah, because it's investigations, it's not, there's no tie that the reference to the defendant that he was actually a defendant in a criminal proceeding, something along those lines, right? I mean.
But this court has recognized that when there are multiple violations, at some point, the sustaining of objections is no longer effective. And again, I repeat, this isn't a mistake, this isn't a stumble, this isn't a bad choice of words.
Was this a new prosecutor?
Pardon?
Was this a new prosecutor?
Not that I know of, I believe.
This was a serious case, so
This very
presumably there was
serious
a
case.
seasoned prosecutor on
Seasoned
this
prosecutor,
case.
serious case, yes.
So a prosecutor has an obligation to uphold the law in a serious way. They have the obligation to seek justice, just as we all have the obligation to abide by the court's ruling, but they are supposed to be, really seeking justice in the way that, one talks about it, as opposed to representing a particular client.
That's correct.
So in this case, I wonder, was it at all confusing when the court made the ruling?
On
Is
page,
there something about the court's ruling that's confusing?
not at all, not at all.
So
And-
even if the first, second objections went away because perhaps a defense attorney didn't want to stand in front of a jury and make an obvious objection that would harm its client, and thought that the prosecutor might abide by the judge's ruling, and then finally at 4, 5, and 6 made objections. Was it not clear by the 4th objection that there was an objection to the violation of the ruling?
Absolutely, absolutely clear. And the judge said, make it stop, and came back the next morning and repeated to the prosecutor that it wasn't to come out again. This is at page 734 of the trial transcript. Repeated the following morning to the prosecutor that it wasn't going to come out again. Then the prosecutor gets up in summation and does it.
So the question here, there was a curative instruction, and one could argue that the evidence here was rather overwhelming. So the question is, do we reverse this on that basis to make a point to the prosecution that it is outrageous when you are given an instruction and it is a violation repeatedly? What do we do with that?
I think that's a legitimate ground for reversal, yes, when there is complete ignorance, defiance of a court's order. Yes, I believe that's a legitimate ground for reversal. And I also believe in terms of the weight of the evidence, it was not an overwhelming case against Arcadio, as we argued in the weight of the evidence point in the brief.
Thank you.
Thank you, may it please the court.
Counsel, I'm just going to ask that you not repeat, okay?
Of course.
Okay.
No, I'd actually like to just put a finer point on the harm issue, because I think I can do that. And just a couple of quick distinctions. Juan Ramon is my client, and he is the subject of the repeated improper commentary. On summation, the prosecutor gets up and says, then when Bernard Malone was in the surveillance room, it hits him like a ton of bricks. That is Chichi Rivera. That is the person he recognized from previous investigations. This isn't some offhand remark about investigations that doesn't implicate our client. This is Malone who gets up and says, I'm the heroin expert. I'm the guy in New York that investigates major heroin trafficking. And then 20 pages later says, oh, he was from a previous case, he was from a previous incident, he was from previous investigations over and over.
And it was clear that this directive was given to the prosecutor before the special agent, I believe this is the special agent?
He's a special investigator.
Special investigator. Before he takes the stand, and it was expected, I think the judge said it, but I'm not sure, instruct your client, the witness, not to say that, to instead say previous knowledge.
Correct. So previous knowledge is the instruction, and the prosecutor, of course, has an obligation to prepare her witness, and I think we would be on solid ground if the only problem were Malone's repeated references during the trial, but we have something much worse, because after all of that happens, the court comes back and says, make sure it stops, and there's this substantive argument made by the prosecutor on summation about how the case is cracked. It's cracked when Malone sees Juan Ramon on the video and realizes he's the guy from the other investigation. This is to say that Juan Ramon is a known quantity in the heroin network in New York, in effect, and that's what is ringing in the jury's ears when they go back to the courtroom. There's no way to fix that at that point.
Neither of the defendants in this appeal had priors, correct?
Correct. That's correct.
And also, there's no forensic evidence except for their presence in the apartment, which is significant. But there's no fingerprint evidence. There's nothing, no ink from stamping the glassine envelopes on their hands.
Correct. No forensics. None of the other types of evidence that you often see in these special narcotics cases, like incriminating text messages sent back and forth about locations, things like that. There's no cooperator. This is a relatively weak case in that its presence. You're in the apartment and there's heroin in the apartment, and a little bit more than that, of course. But you don't have a number of factors that you often have in these cases that make them overwhelming. And that's...
Counsel, I just want to go back.
Sure.
Counsel, I want to go back. You can look over here to the end.
I'm sorry?
I'm sorry. No, it's fine. I get it with the math. I get it.
It's so hard. Yeah,
Don't worry about it. It's fine.
Appreciate it.
I want to go back to the summation, what you just indicated, because I was under the impression that right after that, there was an objection which was sustained, right? And didn't the court give curative instructions that the jury should disregard any comments to which the court sustained an objection?
That's correct, and we're not attacking curative instructions. We're not arguing that all curative instructions don't work. The question here is when it's something truly prejudicial at this very, very sensitive stage of the trial, the curative instruction only goes so far. You can't unring the bell. And there's a case from this court at the end of last year called Challenger, which we cite in our brief, that says this exact thing, and that case is almost the same as this.
No, I understand, but let's look at the evidence, because, you know, it's a lot of evidence here with respect to Juan Ramon, because he was seen on surveillance video with keys. He's going in and out of the apartment very often. He's the last one to leave. He's carrying things in, he's carrying things out. No furniture in the apartment, just tables and chairs. The windows are blackened. Various drug paraphernalia, you know, et cetera, et cetera, et cetera.
And so I think this is the real problem. We don't know whether the jury went back and said what you just said, or whether they went back and said, all right, give me a break. Juan Ramon's the guy who's been in all of Malone's prior investigations. We'll convict him on that basis. I think this is what harm looks like. This is the reasonable possibility.
My question is that you're looking for a reversal. Is it more that you're looking that the trial court erred in not granting your motion for mistrial?
Correct, yes.
So you're asking us to reverse the denial of the motion for a mistrial.
Correct, otherwise...
And we know to get a mistrial, it's a heavy burden to get a mistrial.
That's correct, and this is where we're at. This is where accountability happens, right here.
This is it, right. This is, you're asking us to reverse the trial court's denial of a motion for mistrial. That's
He deserves a new trial,
Okay.
correct.
Got it.
Thank you.
Thank you.
Good afternoon. May it please the court. Rachel Bond for the people. Starting with the mistrial issue, I'm not going to sit here and say that the investigator should have said prior investigations or that the prosecutor should have said it in her summation. It should not have happened. However, there's been no real showing here that the defendants were prejudiced. The jury, heard that both Juan Ramon and Arcadio, in fact, had no prior arrests, warrants, convictions, any sort of criminal record whatsoever.
They were just mixed up in stuff.
Well, and I think as we pointed out in our brief, that was remarkably similar to all of the defendants' theories at trial, which was that they had just sort of gotten mixed up.
No, I don't mean that necessarily, but that they were just mixed up in prior drug stuff. I mean, what else does it mean when you say that there's been, I know him from a prior investigation or something like that? What else does that mean?
So that could have multiple meanings from a person who is an investigator in these kinds of cases. It could mean that Juan Ramon had been seen on some sort of surveillance camera near another
Or it
location.
could mean that, you know, he was involved in another case like this one. That's precisely, all of the things you just said is precisely why the court made the ruling that the prosecutor was crystal clear on, I'm sure, and that the witness would have been told the ruling was made. This is what it is. Stay away from these words. Use this word.
Correct.
Since they all agreed to it. So, you know, at what point is it that this should be, if we do nothing here, you said there's no evidence. How do we know? Nobody polled the jury to say, hey, did that have an effect on you? That wouldn't be done. There was, as was said, this was a case, yeah, windows were blackened, you know, there was lots of drugs everywhere with no evidence that anybody was living in this apartment, but there were other indicia that weren't there that maybe one would expect in a case like this for these two people. So how do we know that the violations in many different ways of the court's ruling didn't impact this. And if we don't do it here, what is the message we are sending to prosecutors who don't follow, or any attorney who doesn't follow a court's ruling?
So to start with about this case, I think it's really about whether or not the trial court abused its discretion in deciding not to grant a mistrial, and that is a drastic remedy that should only be rarely granted. And it's within the trial court's full discretion on whether to do that. I think it came into the trial court's analysis here that there was no explanation about the prior investigation. So there was never said that he was a suspect. It was never said that he participated in a crime at that point. And then each objection that was raised was sustained. The jury was told multiple times to disregard comments to which objections were sustained. And I believe the comments were also, he further ordered that they would be stricken from the record. So, and the jury is presumed to follow all of those instructions. As to...
Let me just ask you a question.
Yes.
Investigator Malone is an investigator.
Correct.
So the ruling was that he was only supposed to answer that he had prior knowledge of Mr. Corto Real, and he knew him as Chichi Rivera.
Correct.
So the inference is, where would he have obtained that prior knowledge from?
Correct. That was another point that we raised in our brief, which was that the difference between saying prior investigation and prior knowledge was minimal at best, and so it didn't prejudice the defendants any more than it would have if he had said prior knowledge, because he is an investigator for the Office of Special Narcotics. And just back to what message it sends, I just don't think that this is a case. There was overwhelming evidence here. All of the...
Counsel, isn't there an important distinction between personal knowledge and investigation? In other words, he could have known he was known as Chichi Rivera, because, if that was the name, I forget if it was correct, because he was a brother of somebody who was involved in an investigation, or he was an informant, or I just knew him from hanging out around the block. I mean, I don't see the congruence between just personal knowledge and investigation. Investigation is a word that's freighted with meaning.
Correct, but I think saying that you have prior knowledge of somebody, even if it is because you know them, because they were a brother of somebody who's being investigated, or because they were on a block where you were doing an investigation, all of that still comes from knowing him from a previous investigation. And there was still no explanation by the investigator as to, you know, whether Juan Ramon had participated in a crime or become a suspect. He also never said that Juan Ramon, importantly, became a suspect in this case because he recognized him. I understand the prosecutor said that it hit him like a ton of bricks, but she was actually, in the course of explaining all of the investigator's steps in this process, the investigator actually testified that he just recognized him on the screen, and that later...
There was no link to criminality when he said investigations. I mean...
Correct.
That to me, that's a very critical point. I mean, if he had blurbed out some sort of indication linking him to something, then you'd have a real big problem, right?
Yeah, there was no mention of criminality with the prior investigation, and he never said that Juan Ramon...
But that's what's expected that the jury is going to be thinking about. That's why the judge goes through trouble to have a prior conference to speak about prior knowledge, which doesn't have any hint of criminality, whereas, as my colleague has already said, investigation does. So the fact that he says the word later on, and it might be 2 sentences after something else he says, it's already, the word, especially when it's repeated so many times, it's already there. Jury's sitting down and thinking about it.
Yes, I understand, and I'm not going to...
I know you understand, so
I'm not going to say that he shouldn't
finish your argument.
Just as to the summation point, again, it was a single comment. I believe the defendants have said that it was multiple comments. It was, in fact, only one where she said prior investigations, and that comment was objected to. The objection was sustained. It was later stricken from the record, and again, the jury was instructed multiple times to disregard those comments. So if there are no further questions, we ask that you affirm.
Can I just ask one question? Sure. Counsel, I thought it was mentioned, maybe investigation was mentioned 2 or 3 times, but then in addition to that, I knew Juan Ramon from a different case, quoting. So there were 6 instances where he said I knew him from a
Yes,
different case
I'm
or
sorry.
an investigation, correct? I just
Yes,
wanna make sure.
there were 6 for the investigator. The prosecutor in her summation only
Oh,
mentioned it
I'm
once.
sorry, I misunderstood
Yes,
what you said.
no, that's
Thank
okay,
you.
yeah. Thank you.
Thank you.
Counsel, I have a question. What is the prejudice to Arcadio Cortorreal when the prosecutor says, when the investigator says that he knows Juan Ramon Cortorreal from a prior investigation?
I think this is all part and parcel of a narrative that isn't justified by the evidence that the prosecution was trying to sell in this case. And that also goes to the violation of the orders not to mention, like, the Latin American provenance of the drugs. And it's all part and parcel of the prosecutor trying to create this image that this was a much larger drug operation, that it was connected to, excuse me, connected to international cartels, it was connected to international drug trafficking, and that all of that was part and parcel of trying to sell a narrative.
Is that how the case was tried, that this was part of an international, cartel? Or was it tried simply and solely that this was an apartment in the Bronx that was being utilized as a drug factory?
There were 3 law enforcement officers who testified. Of the 3 of the law enforcement, there was Malone, there was Hernandez, and there was the third whose name I can't recall quite now. And in all 3 of them, during their testimony, they made sure to get in that I've got experiences with international cartels, I've got experiences with international smuggling of drugs. It's clear when you look at...
Wasn't that part of their background information as to their experience as law enforcement officers?
It was utterly unnecessary to any background to say that they could easily say, I've had experience, widespread experience with heroin investigations, widespread experience with narcotic investigations. I've made hundreds of arrests in New York. They could say any of that stuff. Instead, they chose to talk about Latin America and international cartels. It's clear the image they were trying to create in this case. And then, again, if the 6 violations, if you look at the 6 different violations where Malone testified, and all of them, he doesn't just say previous investigations, he talks about different cases. He uses the plural investigations. That's the narrative throughout all this, that this is part of something that's big. This is part of some much larger narrative than what you're hearing at trial. There's evidence that you haven't heard. It's all part of that narrative. And as I said in my opening, in looking at it in the interest of justice, even going beyond the prejudice, I think there's substantial prejudice, especially as weak a case as they had against Arcadio Cortorreal. But if you go beyond just even the prejudice, in looking at the interest of justice, there has to be a consequence for doing this. When you're told not to do it, when you're told make it stop, and you're a professional prosecutor, an experienced prosecutor, and you walk up in front of the jury and do the exact opposite of what the judge told you to do, there has to be a consequence. Thank you.
Just briefly, I want to go back to the question of whether investigations links to criminality and just focus back on the language that Investigator Malone used. He uses investigations, but he also uses incident, and he also uses case. All of those, as Justice Renwick pointed out, all of those suggest some kind of wrongdoing, especially when they come on the heels of Investigator Malone's CV, essentially, which is that this is his ballywick. This is what he does. He goes after heroin traffickers. So I think there's unquestionably a link to criminality, which is why the judge is so careful with the language in the pretrial conference. The last thing I'll say is that when we're up here debating whether it's 7 instances of misconduct or 8 instances of misconduct, that's where we really need the court to step in and provide some accountability for the prosecutors. Thank you for your time.
Thank you. Thank you all. Rutgers Casualty versus Smith?
May it please the court. My name is Stephen Verveniotis from Miranda Sloan Sklar and Verveniotis. I represent the appellant Rutgers Casualty. The essence of this case is that there's an underlying accident with a forklift, and
We know the facts. We know the facts.
and from that, the insurance company discerned that this insured wasn't clear or accurate in the information that it has repeatedly given over to them. The insured was asked to describe the business, other entities that have had work with this principle. And we found out after the incident from looking at the Department of Buildings, going for years back, there's a variety of work.
So don't.
Plumbing, HVAC, yes, sorry.
No, it's okay. You just finish your sentence and
I just
you're
wanted to
seeking
say-
summary judgment here, right? Because you said that there were material misrepresentations made. But so for summary judgment, obviously, you have to eliminate all issues of fact. And the question is whether or not you've done that with regard to materiality, where I don't see in the record that you've actually found that the individual made a misrepresentation at the time that the insurance was issued.
Yes, Your Honor, they did. They made a misrepresentation about describing other business entities that had done work, because the reason the insurance company collects this information and inquires about who they are is because they go to do the searches and to look for
Counsel,
them.
I'm sorry, just, do you have a record site for where in the application the defendant was asked to disclose his prior work history?
Yes, Your Honor.
Thank you. I don't mean to,
If I can do it on rebuttal,
That would be
I'll
fine.
find it. I know I have it, but.
That's fine.
As usual. But from the circumstances that we know, the record about Mr. Basso is that he has had a variety of type of work. He's had HVAC, plumbing.
So what does NOC mean in this? And by the way, I think this document you're using is not signed. Is it? Is it signed by?
The version that we have is not signed, but it still is the version that the insurance company was provided through the broker and based its analysis in order to issue the policy. They don't-
But he's not.
I'm sorry.
But without a signed document, I don't really know how you can hold him to those things that were said. But I was asking a question about NOC.
Yes.
Not otherwise stated or considered, or, I mean.
Not otherwise classified.
Classified, that's the
Right.
word. And it wasn't defined. So how do we know that that doesn't take into consideration some of the things on the list you just iterated?
You mean NOC wasn't
Yes,
defined?
yes. Mm-hmm.
Well, NOC is a term of art that they use
broad
in the
term.
insurance industry. Well, nothing else is what essentially it means.
Is it defined in the policy?
I don't think it's the kind of thing that warrants a definition, Your Honor. Like I said, it says nothing else, essentially. But when we say carpentry, we mean nothing else. That's like asking, well, the word nothing isn't defined. You haven't told us what nothing is. The essence of NOC is to make it clear that nothing else other than carpentry, which has been determined by case law to be working with wood. Meanwhile, here, there's a much more elevated risk that we can see from the forklifts that caused this accident and the steel metal contractor that contracted them to do the steel metal sheds. They were not doing carpentry here, and they didn't disclose it. And to go back to the unsigned document, it's not like we're trying to enforce a contract and it's not signed, Judge. The essence of rescission is that the application for the policy is you gave us a document in submitting it. When a broker submits something, whether it's signed or not signed, The broker is presenting, this is the information that we're giving you for this entity that's looking for coverage. The
It's up
insurance
to the,
company doesn't.
it's up to the insurance company to decide what documents it's going to accept before it issues a policy. It's an unsigned document, that's all I
True,
can.
true, but the essence of rescission, Your Honor, is you gave me this information, I relied on this information and issued you this policy.
Right, so the question is whether or not those things have been found as a matter of law to be, material misrepresentations. That's really, I don't know that we can determine that on this record, can we?
Well, on this record, yes, we have the underwriting guideline and we have the representative of the insurance company saying, here's what we say in our underwriting. If we knew it was steel work and if we knew forklifts were involved and if we knew they had 10 employees, we would have not given them this policy. We would have had other provisions. We would have charged different premium. There's different calculations that insurance companies do depending on the information. And it's got to be that you hold the insured to the accuracy of the information that you give to the insurance company. It's not a contract that we're trying to enforce the information that they gave us. But when they give us wrong information, they should be held accountable for the wrong information.
Was there a question?
Yeah, I just want to
Yes,
go
Your
back
Honor.
because the application, not only is it not signed, but it's also not dated. And the claims adjuster, you have two different versions here. You have Basso saying what NOC means, and then you have the claims adjuster who gives a different version of what NOC means. I didn't see anywhere in the record where the guidelines set forth what NOC means, and this claim adjuster doesn't even state how he learned the information. And just for example, that LinkedIn page from 2020, it has the range of employees from 1 to 10. We know in the application it said 3, but that 2020 LinkedIn page doesn't indicate how many employees there was in 2017. So I just see a lot of gaps here.
True as to the latter point in terms of number of employees, but we know at this particular job site they had more regardless of the 2020. With respect to the NOC, Your Honor, to have somebody who's not in the insurance industry give you his opinion of what NOC is essentially irrelevant when somebody who's got a background in insurance says, this is what NOC means. Now, to read in NOC that using a forklift and sheet metal and metal steel work is what is intended is quite a leap in this situation. And with respect to the dating, clearly that was given to the insurance company predating the issuance of the policy. As the
Thank you.
affidavit says, you wouldn't get the policy without an application.
Thank you. You'll look for that information on rebuttal.
Yes.
Good afternoon, Your Honors. May it please the Court, my name is Anthony Abrascati. I'm the law firm Nicolini, Paradise, Ferretti, and Sabella. My office represents USA Veterans Construction, the respondent in this matter. From the onset, what I will say is, and I think the Court was sort of prodding at this is a case where summary judgment was filed before there was any discovery completed or done. There are many questions of fact that raised themselves, quite honestly, in the papers. What Your Honor mentioned about the number of employees, they're citing to a LinkedIn page from years after the application. When they're talking about Mr. Basso's prior work history. They're not talking about, number one, USA Veterans Construction's work history, which is, it's a new company when he was applying. So, number one, they're talking about Mr. Basso, and number three, the application doesn't request that information. So the insurance company, in this motion for summary judgment, out of one corner of its mouth is saying, well, he didn't provide us all of this information, but then on the other side, it was never asked for. They issued a policy without any of that information being sought. That's not a signed application, as Your Honors have seized upon. Additionally, the umbrella policy application is also unsigned. It has what we're now seeing in Zoom Life, where people have an electronic font where somebody wrote that in. It's largely blank. The applications don't have any information. We have had no discovery. We do not know what brokers submitted what, if there was a mistake, if there was something else. But the point is that the facts Mr. Basso also submits shows that there aren't any factual issues as to whether or not he misrepresented things. The insurance company has clearly just jumped on things prematurely in this suit, attempted to carefully curate some documents without them being in an admissible form, and we now have a situation where we're before Your Honors when we should be completing discovery in the case. If Your Honors have any question, otherwise I'll rest on my papers.
Thank you.
Thank you.
The location in the record is 126, page 126.
And what does it say there at page 126? Would you just?
If only I had my glasses, Your Honor. I know, I see from my brief that I'm referring to 125 and 26. Unfortunately, my eyes are
Okay, it's all right.
challenging me at this moment.
We have it.
But just to briefly recap and respond to the argument, it's not that the insurance company is glomming on things. In all candor, this is an issue that happens over and over. Carpentry is one of the lowest rated and lowest premium to the insurance company. These contractors come up, they say that they're doing carpentry in order to get a low premium, and then only when you have an accident do you find out, like we did in this case, that lo and behold, they're doing all kinds of other stuff and have been doing all kinds of stuff for years and years. That's why they ask for this information in order to the insurance company, so that's an equal communication from both sides. You're giving us this information and you're telling us, trust you to give you a policy of insurance. But if that information isn't accurate, the remedy of rescission should apply in this situation. And I think we've given you the underwriting guidelines and the documents that were submitted to the insurance company. They're not challenging that these items were submitted. They're saying, oh, we don't know what broker submitted. These are the documents. These are the insurance company documents that were the basis for issuing the policy, and they're just not accurate. Thank you, Your Honors.
Thank you. Thank you both. Schukenhaus versus Frolova.
Can you hear me?
Yes, sir.
Oh, good, thank you. May it please the court, my name is Stephen Weingrad. Firm is Weingrad and Weingrad. I represent the appellants. The underlying appeal, the way I saw it, focused on the issue of res judicata. And I don't want to waste a lot of time talking about it because I feel my adversary admitted in her brief that the prior dismissal was a sanction of dismissing the complaint for failure to appear at a deposition, which was previously argued that that was not true. But in any event, that was what Judge Perry is saying is a dismissal on the merits. And therefore,
I thought Judge Perry relied on the Gershkovich decision, not the Schuken versus Iceve decision where there was that discovery sanction. I thought he was relying on Gershkovich, and where Iceve was not a party in Gershkovich, correct?
Iceve was not a party where?
In the initial appeal that you brought here in 2019, Gershkovich?
Ah, Gershkovich.
Yeah.
Okay. And that raises a great deal of confusion. So let me back up for 1 second. The way the case came about is my client was looking for funds and went to Iceve, so to speak, an accountant, who introduced him to Gershkovich. Gershkovich was an oligarch. He lent him $5 million, and paperwork was drawn up. A couple of years go by, they buy the art, or they had the art, and everybody was happy with the appraisal for $63 million. The art was shipped to New York. Everybody lived abroad. My client lived in Estonia, Gershkovich and Iceve lived in Moscow, and Ms. Frolova, who represents them, is in Moscow with offices here in New York. And So the Gershkovich decision is res judicata on the issues of a contract that predated the theft. I think I mentioned it in the brief, it shouldn't be confused. A lot went on over a few years. And so when he sued on his note, he won. This court affirmed it. But that contract predates the theft and the settlement. Now comes 2015, when the Rosenberg appraisal comes out here in New York, the $63 million. And what happens is ISIV comes to New York and says, I think I have a customer for it. And what he was saying was, I would like a finder's fee for introducing you to Mr. Gresham.
Right, and you sued Mr. ISIV, of course, and then there was the appeal, the latter appeal, where Shulkin versus ISIV, and we affirmed the dismissal based on discovery. It was a discovery sanction.
Correct.
But counsel, why should you be allowed another, or why should your client be allowed another bite at the apple, having...
There's been no bite at the apple. There's never been a trial. There's never been a hearing on the merits. It's only been sanction, and dismissal for discovery.
So isn't that just an end run around the sanction of, like, you had your bite at the apple in the sense, let me finish the question, counsel, let me finish the question.
I'm sorry.
You had your bite of the apple in the sense that you got a chance to sue Mr. ISIV, and then the court found, no, you don't get to go forward with your lawsuit anymore because you didn't comply with discovery requirements. And so then you're just allowed to bring a whole nother lawsuit? That's what you're saying?
Yeah, that's what the CPLR says. If it's dismissed not on the merits, you can restart within 6 months. And if there's an appeal taken, it's extended 6 months from the finality of the appeal. That's pretty, that's in there. I don't know where, but that's basic. A dismissal not on the merits affords the litigant 6 months to restart on the merits, and that's what we did.
Well, it's true that, I think you're referring to 5013, that's CPLR 5013.
Perhaps.
But isn't it correct that it's not necessary that the decisions say that it's on the merits to still kill a claim?
Well, yes, that's true. It doesn't have to say on the merits, but it has to be on the merits. And there was no merits. It was never heard on the merits. Yeah, it was dismissed. If you want to go into that, it was dismissed because he specifically said what my adversary said in writing on a handwritten PC order, that the client never appeared for a deposition in Moscow, which was an absolute incredible lie. And
that horse has left the barn, though, correct, counsel? In other words, that's already been decided. We can't go back and revisit that decision, correct? In other words,
you can't revisit it.
You're stuck with that.
You can't revisit it here, but it will be decided in a higher jurisdiction eventually. There will be, this is not $63 million.
Counsel, correct me if I'm wrong. I'm over here.
Oh,
sorry.
It's hard.
So let me see if I understand the facts here. Your client wants to regain possession of artworks, correct?
Correct.
Okay. And that all stemmed from a fact that there was an agreement, a loan, that the defendants provided your client, and in exchange for the loan, they used the paintings as collateral?
No, there was never any taking of collateral.
There was never an agreement?
No. My client owns the art 100%.
Yes.
Has owned it throughout the lawsuit 100%.
So how did the artwork go from your client to the defendants? What happened in that transaction?
Which transaction? Before the theft or after the theft? The Gershkovich case, which was cited, took place on a contract that predates the theft. The theft took place here in New York 3 years or 2 years later, when ISIV came and said, I want a finder's fee, I have a customer, and he took the art and kept the art and never returned it. Within 1 month, a signed settlement agreement was entered into, September 2015. ISIV signed a settlement agreement. And then Ms. Frolova, who was trying to represent Gershkovich, went to him and said, we have a signed agreement that now ISIV is going to get some money. I can do something for you. So Greshkovich comes in to improve his condition. And that's the contract that's different from the one he sued on. And that's where the mistake was made, that they relied on, or the judge relied on a contract that predated the settlement. So now Greshkovich comes in, and now this is a very important part of the case. Ms. Frolova takes a retainer contract from both Greshkovich and ISIV and puts in the retainer, there may be a conflict of interest, I'm disclosing it. Fast forward, she enters the judgment for Greshkovich. She's representing ISIV, who's holding the $60 million worth of art, and he says, execute on the art, and she says, I can't. There is the unethical representation, which was disclosed and should have been walked away from, and they should have gotten new counsel. But they don't. Instead, she comes to New York, makes an application to fix fees, testifies before a special referee that the bill from Greshkovich is paid, $250,000 paid, complete with expenses, and files a motion to have a retaining lien against, this is not what I wanted to argue today, a retaining lien against the proceeds that Greshkovich get. And he files an affidavit, you have to read it. He says, she's a liar, I fire her, I never signed that affidavit, and I never gave her 15%, and she proceeds, and Judge Getz says, you can get 15% of what he gets, and she's fired.
Thank you. Thank you. You have rebuttal.
Okay.
I gave you quite a lot of time because
I know you did.
I didn't start the clock.
I
so-
appreciate the fact there's a lot of money at stake. I would be remiss if I did not say.
Well, you can say it on rebuttal. You have rebuttal. You're going to be back up again.
Good afternoon. My name is Irina Frolova. I represent myself per se. I've been sued for almost $1 billion of US dollars, only, as I already stated, I think out of spite and will, because I successfully represented to my previous clients. Most of the remark in appeal brief, in reply brief, it's just a false. I never drew any agreement. I am a litigator. I've been hired to litigate, and I've done my job. And in this 110 exhibits, there is a decision of the motion court, and there is a decision of appeal court who affirm of this decision. So I think it's obvious that the appeal is frivolous. The only issue is it's my request for sanction and cost. And I believe that your discretion, Your Honor, is supposed to be exercised.
You're not a party to any of these agreements or transactions, right?
I'm not a part of anything.
You just happen to be the lucky lawyer representing the defendants in this case. And now you're being sued personally for being, I guess, allegedly involved in these transactions.
That's correct, Your Honor. I've been sued probably for two reasons, as I understand, to harass, and second reason, to try to serve my clients through me. I cannot explain why I'm here. And I will continue, if it's allowed, that discretion is, I believe, supposed to be based on the principle of fairness and equity, and it's unfair without any remedy to allow one attorney of this court to publicly harass another attorney of this court by bringing false accusation of criminal unethical conduct. And it's also unfair without any remedy to allow one attorney of this court to waste time and resources of another attorney of this court, because CPLR doesn't provide any provision for me not to reply to his motion, petitions, appeals, even though they're without any merit in law and fact and based on false material statements. I'm done.
Ms. Frolova, before you go, the court below dismissed the case on res judicata grounds, but I take it that you say that there are alternate grounds that easily the case could be dismissed against you personally.
Yes, it's based on documentary evidence, and documentary evidence, first of all, there is no settlement agreement. There is no single document which in essence or by its name refer as a settlement agreement. And in appeal brief and a reply, my adversary doesn't discuss which specific agreement is a settlement agreement. So he's just called a bunch of documents. Maybe we will find some of them from these 110 exhibits, I don't know, to justify his bringing of the case.
Yeah, so in other words, there's no contractual obligation on your part or any other form of liability apart from this res judicata ground. You're making that argument as well, that none of the documents show that you personally.
No, there is no document shows that I'm personally involved. There is no first of all, there is no document at all, not only regards to me, but toward my client, my former client, and my present client, and towards me. And second, there is there is no agreement exist.
Thank you.
Any other questions? Thank you.
Ms. Frolova is in the case. She's a 15% interest in the art owned by, in the recovery from Greshwich. I can't finish a $60 million lawsuit against the perpetrators unless I bring in all those who have a claim against the proceeds. So she is in the case. She made that application to get the 15%, and she's got to live with it. The service that she talks about, it's incredulous that she's still talking about it. I served the summons on her law office under 408, and Judge Perry, first he says, I mailed it without permission. And the CPLR says, if a lawyer, whether it's a foreign lawyer or a domestic lawyer, is representing a foreign national here in New York State, service is complete by delivery to the lawyer. And that's what I did. And so Judge Getz fined me $32,000 for not mailing it to her, and Perry fined me $5,000 for mailing it to her. And now my time is up. You cut me short.
I didn't cut you short. I gave you 4 and 1. I let you have about 10 minutes in your main argument, and I just gave you 1 for rebuttal. I will allow you a minute to finish whatever you're saying. Go ahead.
There was, before this court, an Article 78 to compel the judges to release the note with the address.
Counsel, I wouldn't dwell on that. That was absolutely a frivolous application. I sat on that panel.
And you denied it.
Correct.
And I renewed it last month, and you denied it again. And I based it on the High Court of Estonia, which is the highest court.
Counsel, what is the purpose of that tangent? Talk about
the purpose is a higher court than this resolved the issues. That's the purpose. They resolved the issues. The highest court of it, the party lives in Estonia. They sued him in Estonia. They resolved the issue, the underlying issues, everything. And they said, we have to sell the art in 6 months. And this court rubber stamped it. It's not relevant. I'm up in the Court of Appeals. That's why I'm remiss. I have to tell you that I just filed for permission to go to the Court of Appeals. I have a client with $60 million worth of art, and he's completely shut out based on Judge Getz getting a piece of paper and saying, I'm not going to tell you where your art is. We didn't just ask him to deliver it, insure it, or anything. Just tell us where it is.
Thank you very much.
Thank you, Your Honor.
Thank you both.